Morning. It's an honor to be here. I'm the last speaker between you and the coffee break. I was working and researching on the topic of guerrilla tactics for 3 years. I've now 15 minutes to present you the results, including emerging changes. Otherwise, I was told guerrilla tactics will be used against me, including a trap door which will open and make me fall into the basement if I exceed by more than a minute. Let's see whether that will be successful. This is my ambitious table of contents. I will quickly describe the emergence of the arbitration guerrilla phenomena, talk about council as a target of new regulations on newly discovered competences, discuss rights and duties of the arbitral tribunal to fight guerrilla tactics, present traditional tools and new tools, and offer a very humble conclusion and outlook. If you want to have a PowerPoint presentation, please give me your business card. I'm happy to send it to you by email. That was a little bit too ambitious. I'm aware that there is a distinction between a so-called black arts or rough riding and guerrilla tactics. So not everything you do not like is a guerrilla tactic. Guerrilla tactics, that includes a violation of the law or procedural rules. The intended aim of the guerrilla tactic is to obstruct, derail, or sabotage the arbitral proceedings, and that needs to be done deliberately. That means a conscious tactical decision. That does not mean sometimes people are stupid or badly organized and counsel tells you, oh, next week is the hearing. I just realized that my heart surgery is scheduled for next week as well. Normally that is a tactical decision people know and they want to derail the arbitration. Sometimes it's simply stupidity. The guerrilla tactics, the arbitration guerrillas, they act deliberately. Extreme guerrilla tactics, that includes severe criminal acts. That includes, for example, killing witnesses if they might be harmful. The black arts or the rough riding, that is ethically borderline conduct, which is technically still legal. I give you an example. A hearing is scheduled to take place in a small resort somewhere in the Swiss Alps. There is one hotel with 100 rooms. The chairman thinks that is good enough for everyone. And opposing counsel just reserves all the 100 rooms, with the consequence that you may travel every morning 40 kilometers. That is rough riding, black arts, borderline. The overall of the guerrilla tactic, once more, that is delay or obstruct arbitral proceedings, manipulation of the arbitral proceedings by means of fraud, threats, violence, bribery, stealing of information, etc. And how does this look like in practice? Action against arbitrators, stalking, bribery, repeated challenges. There is one case with 13 challenges against the arbitrator. They were all not successful, and here comes the 14th challenge, and the reasoning is, you must be very mad at me now because I filed already 13 challenges against you. That's probably correct, but I'm just wondering whether such self-created reasons should qualify as a reason for challenge. Civil lawsuits, that's also meanwhile fashionable. One of my partners was a chairman in an ICC arbitration, and during the arbitration he was sued in New York court because he allegedly disclosed something to a mediator candidate. The claim was not successful, but pursuant to the American cost rule, he was stuck with costs of 100,000 USD. Was he happy about that? Certainly not. The consequence is another challenge. Hey, I sued you in court. You had to pay the fees. You must be unhappy with me. And of course, that is correct. And the question is, these self-created reasons for challenge, should they have merits? Other eyebrow-raising events, there's a Swiss colleague who once realized that his rubbish was searched by detectives, wiretapping, of course. And there is the case about a chairman in Chicago who was sent a young female associate, and someone standing in front of the door on the chairman and realizing she got in the evening and got out next morning, and whatever they did that was not disclosed, challenge. Action against council or parties, intimidation. I was once told if you come to the hearing, you better wear a bulletproof vest. I consider this to be a very friendly recommendation. Wiretapping, more or less standard. Frivolous filing of insolvency proceedings. We once represented a Japanese car maker, and the opponent was all of a sudden filing insolvency proceedings against the German subsidiary. Said, I have a claim of 80 million against the German subsidiary. Their capital is only 50 million. We argued, A, this is completely crazy, and B, the Japanese parent company stands behind the subsidiary who is worth 20 billion euro. What was the consequence? The claim in the German insolvency proceedings was raised to 25 billion. So, I mean, these are guerrilla tactics, frivolous filing of criminal procedures, because, of course, the other party is cheating. This is a fraud, this is procedural fraud. Hey, and the lawyers who participate in that, they are assisting in criminal proceedings. And I tell you, your managing partner, if you're a practicing lawyer, doesn't like it if criminal accusations are raised against you, no matter whether they have merits or not. And the physical attack, a Swedish colleague told me he had a meeting in Moscow. He was a little bit late. He is tall and blonde, and he said shortly before him, an auditor from KPMG tried to enter the building, also tall and blonde, and this KPMG auditor was asked, are you the Swedish lawyer? An answer, well, the person didn't ask for an answer, but hit him down with an iron rod. So my Swedish lawyer friend was happy that he came 5 minutes late and the damage was already done to the KPMG auditor. But again, I mean, guerrilla tactics means it sometimes gets really tough and ugly. Action against witnesses, that's how I got into touch with this topic. When a Japanese key witness who had submitted a witness statement called me and said, I'm better to not come. Opposing counsel has invited me to the law firm, and they told me, do you know who is paying for your pension? And do you know where your daughter is working? And I thought, your daughter expects to have a great career in this company. It's not a good idea to go to this hearing in Zurich. And this happened to me twice. And that's why I got mad and I got a little bit creative. And the result is a book on guerrilla tactics. The issue is often how do you prove such witness intimidation. More often it's relatively subtle. If you go against certain states, if you try to find a legal expert, it's sometimes difficult because the legal experts who live in the country tell you, hey, I live here, I'm a state employee, or my family is in the country, it's not a good idea to testify against the state. So that's often the challenge. Various manifestations of guerrilla tactics is also shown in action against arbitration institutions. If you talk to ICC personnel, they will tell you that often civil action is commenced against the Secretary General or against the institution just to derail an arbitration. If you do not believe me that a problem exists, then simply look at books such as Obstructionist Behavior in International Commercial Arbitration, Fraudulent Evidence Before Public International Tribunals, Counsel as Client's First Enemy in Arbitration, And of course, and here comes the commercial, my book promotion, Guerrilla Tactics in International Arbitration. We have already quite some material for a second edition. Now, a topic, an emerging change, which made me very unpopular with loyal colleagues, is that I say, you can go against parties, yes, absolutely, but sometimes it makes sense to also go against counsel who is using such practices. Who can best deal with guerrilla tactics in international arbitration? And I tell you, some actors you often hear, and I consider them to be inappropriate, such as the public prosecutor, local courts, bar association, and then an invention by the Swiss Arbitration Association, a so-called Galactical Arbitration Ethics Council. And I tell you why. Imagine there is a North Korean lawyer who is harassing, threatening a Ukrainian witness in an arbitration conducted in Paris in English language. Now, to which public prosecutor do you want to turn to? The North Korean public prosecutor, forget it. Ukraine, then I mean, first of all, you have to disclose all the information about the arbitration. You have to translate everything. That is not convenient. The North Korean Bar Association, I don't even know whether this exists. In practice, that doesn't work at all. That's why who can best deal with guerrilla tactics in international arbitration? That's for me the arbitral institution, because they supervise the arbitration in any way. They could have an important role in the supervision of counsel conduct. There is no confidentiality issue because they should know the files, and there's regularly no language issues. And they have efficient remedies, we talk about this in a moment, such as, for example, temporary suspension or blacklisting. And of course, there is the arbitral tribunal who could sanction such behavior. Now let's talk about rights and duties of the arbitral tribunal to fight guerrilla tactics. There are explicit regulations which provide for sanctioning power, and there are more subtle implied competences, and I will distinguish them in the following. Explicit regulations which provide for sanctions by the arbitral tribunal are meanwhile the IBA guidelines on party representation in international arbitration. If they are part of the rules, if they are referred to by the parties. In LCIA arbitration, these are the LCIA guidelines for the parties' legal representatives of 2014. And if you look into new arbitration rules, there are meanwhile explicit provisions which give the arbitral tribunal such power. I admit not the very popular arbitration rules. I discovered the Shenzhen Court of International Arbitration Rules 2016, which has such rules, and also not known to everyone, the Lagos Chamber of Commercial International Arbitration Rules. They also have such explicit power by the arbitral tribunal, which I would consider to be an emerging trend. You have implied competences of the arbitral tribunal to fight guerrilla tactics. These are implied powers of the tribunal to preserve the integrity of the proceedings. We talk about this in a second. And you could make an argument that there are contractual or at least quasi-contractual duties of counsel vis-à-vis the arbitral tribunal. As a rule of thumb, I would say if counsel appears voluntarily in arbitral proceedings, this means acceptance of the arbitral tribunal's jurisdiction over counsel's behavior. Now, the traditional tools to fight guerrilla tactics in international arbitration, this is simply initiatives by the arbitrator to obtain relevant evidence. Why did the witness not appear? This is often showing the parties and counsel that arbitral tribunal is aware of what is going on. Kind of, reminders to parties, I want this witness to show up. Adverse inferences, I was told in a Russian arbitration, once a paper was presented to counsel of the difficult party, there was only one copy of that. And what did counsel do? Taking the piece of paper and eating it. The copy was gone. But in such a case, I would say it is fair to assume that the paper was probably not tasting this well. You were not this hungry. You had a reason to eat the only copy. I think this is a very good example for adverse inferences.
And it's time for them to drink their coffee and eat their paper.
Oh, how much time is left?
0.
0. I'm at.
Minus.
Oh.
Minus.
Beware the. Okay, dismissal of the case with prejudice. Public admonishment of counsel, the name and shame. I come to this. Exclusion of counsel from the proceedings. Monetary sanctions. Hit parties and counsel where it hurts most. And then temporary suspension and blacklisting. For a while, you may not practice at ICC anymore or here at the Ukrainian Court of International Arbitration if you don't behave. Admonishment of counsel, only one example. Here's a case, Generation Ukraine against Ukraine, where, it was where counsel relied on outdated cases, was here more or less admonished. If you read this, the names are clear. Counsel is either incompetent or dishonest. You have clearer cases, Wilske, where counsel was excluded from the proceedings. Monetary sanctions, I give you just one example. It can be indirect or direct. Mr. Apple, no, wait. I want to show you this here. The tribunal expresses the wish that Mr. Appleton, the counsel, picks up a fine of 10,000 euro himself. Here you have admonishment and you have the fine. And you have, meanwhile, you can fine counsel directly. And I apologize very much for violating your right to a coffee break. But what I want to say is control over misbehaving counsel is necessary. Counsel may not hide behind prime responsibility of the client, and the arbitral tribunal can deal with that. Thank you very much for your attention. Dziękuję.